Hi, I'm Dan Krause, and I am an attorney in Wisconsin. And today I want to talk about what you can do to make sure that your will is legally enforceable. But first, I want to invite you, if you have any questions about wills or trusts or probate or after death administration of someone's estate, please give us a call. We can help. 608 268 5751. So in my practice in the last few months, I've seen two serious problems with wills and their enforceability or the legality of the will. So what were those problems? Well, they both had to do with the witnesses. A will in Wisconsin doesn't need to have any particular form necessarily, except for there are some requirements. And one of the requirements is you must have two witnesses that sign the will at the same time that the person signs it, or they can sign it after the person signs it if the person acknowledges that that's their signature, but it has to be in close proximity to the signing of the will. So what were these problems that I saw? Well, the first problem was obvious. The will didn't have any witnesses at all. Now, the person obviously believed it was their will. They kept it in their safe deposit box and they told people about it, about their will. And after they had passed away, it came to find out that it's not legally enforceable. It was not witnessed, so it can't be effectuated. And unfortunately, the one person that they wanted to get certain things in their will is not able to get anything through the action of the will. The second issue that we came across recently was the person that made the will had two witnesses, good, but the two witnesses, unfortunately, were two of the children of the person who was making the will. Now, this is doesn't make the will so that it is unenforceable. The will is still a legally enforceable will. However, there's a caveat. Now, the interested parties, which are the children of the person who signed the will, the interested parties are limited in the amount that they can get through the will. The law says in Wisconsin that if an interested party witnesses the will, then they are limited to receiving the amount that they would get if there was no will at all. So the people in this case were some of the bequests that were made to them had to be pared back because it was going to be more than what they would receive if there was no will at all. Now, both of these issues that came up, neither of them had legal counsel, so they didn't see an attorney to draw up these wills. In fact, both of them were written by hand, interestingly. Handwritten wills are not a special category of wills in Wisconsin. However, in other states, they are what you call a holographic will, and they can have special status and they don't have to be witnessed in some states. However, Wisconsin is not one of those states that recognizes a holographic will. So you must have two witnesses. It's a best practice to have two witnesses and a notary. That's called a self-proving will. But the witnesses really ought to be disinterested witnesses, because you don't want to limit your witnesses, if they're interested parties, to receiving less than what you might want them to have. So thank you for taking your time out and listening to or watching this video. And please give us a call if you have any questions about this. Once again, the number is 608 268 5751.